Hey guys, welcome to my legal classes. This is Ganesh Pujari and we were discussing Chapter 17 of Indian Penal Code. This chapter has as many as 85 sections and we have already had 3 sessions, and this is my 4th session where I am going to discuss two important concepts, that is robbery and dacoity. These concepts are discussed between section 390 to 402. Those are 13 sections which I am going to cover in this particular session, and let's get into our first slide. Section 390 defines what is robbery. Now, if you want to understand what is robbery, the first and foremost important requirement is you should understand the concept of theft and extortion. I have already made 2 videos, one on theft and one on extortion. You can refer those videos to understand these two concepts, because robbery is the continuation of these offenses. If there is any theft along with violence, then that is considered as robbery, or if there is any extortion along with violence, then that is considered as robbery. So basically, theft plus violence is equal to robbery, or extortion plus violence is equal to robbery. The case law that you can refer is Rameshwar Soni versus State of Punjab, where a person while committing theft put chili powder into the eyes of the victims. Now he has done theft, along with that he also conducted violence act, so that is considered as robbery. Likewise, the second case, that is Tikat Bhir case, where while nose ring snatched, there was a hurt happened to the person or to the victim, so that is considered as robbery. So most of the time, if anybody is snatching chain etc., it is considered as robbery because their violence is involved. That is what you need to remember as far as section 390 is concerned. Section 392, 393 and 394 are discussing about the punishment for robbery. What is the punishment for robbery? It can go up to 10 years along with fine, and if it is committed in any highway between sunset to sunrise, that means if it was conducted during night, then the punishment can go up to 14 years. Now, these are the cognizable offences. They are non-bailable offences. The magistrate of the first class can conduct the trial for these offences, and these offences are non-compoundable offences. While section 392 discusses about the robberies already been committed, section 393 discusses about attempt to commit robbery. Here the punishment can go up to 7 years of rigorous imprisonment along with fine. The offences under section 393 are cognizable offences, non-bailable offences. Magistrate of first class can conduct the trial, and they are non-compoundable offences. Section 394 discusses about voluntarily causing hurt in committing robbery. While committing robbery, if somebody is voluntarily causing hurt, in that case they can have imprisonment for life or rigorous imprisonment for the term of up to 10 years along with fine. Now these offences are cognizable offences, they are non-bailable offences, and the offences under 394 can be tried by magistrate of first class, and they are non-compoundable offences. While section 390 defines what is robbery, section 391 defines what is dacoity. If a robbery is conducted by 5 or more people, then it is dacoity. So basically there is robbery which is either committed or attempted or aided by 5 or more people. In that case, that will be called as dacoity. So if you want to understand what are the essentials, it was in the case law of Om Prakash versus State defined that the accused commit or attempt to commit robbery, and persons committing or attempting to commit robbery and person present and aiding must be not less than 5, and all such persons should be act co-jointly. Co-jointly means together. So together there should be 5 people. Maybe all of them are committing or attempting, or few of them are just aiding. So they can distribute the team that few will commit, few will join them, or few will just provide support. Whatever way, if the team is 5 or more, then such robberies will be considered as dacoity. So the only difference between robbery and dacoity is, in robbery it is 4 or less people, but in dacoity, whenever the team size is 5 or more, then that will be considered as dacoity. Robbery can be done by a single person also, but for dacoity there should be minimum of 5 people. All of these things are the very essential things as far as dacoity is concerned. Section 395 to 402, they are discussing about the punishment for different types of dacoity, and section 395 says what is the punishment for dacoity. It can be rigorous imprisonment which can go up to 10 years along with fine, and these are cognizable offences, non-bailable offences. Court of session will trial for these offences and they are non-compoundable offences. What if they have killed someone while conducting dacoity? That is what precisely discussed under section 396. There, the punishment can go up to imprisonment for life, or it may extend to 10 years of rigorous imprisonment along with fine. Here, the offences are cognizable offences, non-bailable offences. Court of session can conduct the trial and they are non-compoundable offences. One very important thing that you need to remember is here the punishment is for all the team members, whoever has committed or whoever has aided. That is one very important point you need to remember when discussing about punishment. While section 396 discusses about dacoity with murder, section 397 discusses about robbery or dacoity with attempt to cause death or grievous hurt. Here they have not yet killed anyone, but there is an attempt. And one more important thing is this is covering both robbery and dacoity. And here the imprisonment will be not less than 7 years. It will be minimum 7 years or more. That is one very important aspect you need to remember. And the offences here are cognizable offences, non-bailable offences, and trialed by court of session, and they are non-compoundable offences. Section 398 discusses about attempt to commit robbery or dacoity when armed with deadly weapon. Now you are trying to commit robbery or dacoity and you are also armed with deadly weapons. What happens then? The punishment will be not less than 7 years of imprisonment, and they are cognizable offences, non-bailable offences, and court of session will conduct the trial and they are non-compoundable offences. What if somebody was preparing for committing dacoity and they were being caught? What is the punishment? Here section 399 discusses about the same, which is all about making preparation to commit dacoity. Here the imprisonment can go up to 10 years along with fine, and they are considered as cognizable offences. They are non-bailable offences. The court of session can conduct the trial and they are non-compoundable offences. Section 400 discusses about punishment for belonging to gang of dacoits. Now, if there is a gang which is habitually committing dacoity, and if someone is member of that particular dacoity team, and if they get caught, then the punishment can be imprisonment for life or rigorous imprisonment up to 10 years along with fine. Now these are cognizable offences, non-bailable offences. Court of session will conduct the trial and they are non-compoundable offences. Section 401 discusses about punishment for belonging to gang of thieves. Now what is the definition for gang of thieves? It is minimum of 2 members and maximum of 4 members. Remember, the moment it reaches 5, then they are going to the sections under dacoity. That is very, very important. So minimum 2 members, maximum 4 members. If there is a gang of those members, in that case, when they get caught, they can get punishment of rigorous imprisonment up to 7 years along with fine. And the offences conducted by them are cognizable offences, non-bailable offences. Magistrate of first class can conduct the trial and they are non-compoundable offences. Section 402 discusses about assembling for purpose of committing dacoity. For the purpose of committing dacoity, if more than 5 people are assembling and planning for the same, and if they get caught, the punishment will be up to 7 years along with fine. Now they are also cognizable offences, non-bailable offences, and court of session will conduct the trial and they are non-compoundable offences. That brings an end to this particular class. I will come up with one more new topic on offences related to property in my next class. Till then, thank you so much for subscribing my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you are watching my channel, and thanks again.